Good morning to all of you, and welcome to our jurisprudence class for the second semester. So this morning, we would like to discuss Ronald Dworkin's contribution to legal theory, especially his theory of adjudication and law as an exercise in interpretation, his interpretive approach to legal theory. So we discussed that, and after discussing this with you, there's a particular work he did, which we call the Law's Empire. I usually assign students to read it, and I give you directed questions, which will help you to actually make sense of what you are going to read. So let us keep that in mind, that after this class, I'm going to assign you to read the Law's Empire in detail, as it were. And you should be guided by the discussion that we are going to do now, so that you are able to make most of it. So let me share the screen. And let me say that those who will continue to the Ghana School of Law, and I presume almost all of you want to go to Ghana School of Law, become barristers, and know that there's a course in law school which we call the Law of Interpretation. And if you are going to understand law of interpretation very well, you must have a good appreciation of jurisprudence, certain aspects of jurisprudence. And one of those aspects of jurisprudence relevant to proper appreciation of interpretation is Ronald Dworkin. Ronald Dworkin. So let's take it serious. Who is Ronald Dworkin? The man Ronald Dworkin, born in 1931. He was a professor of law at the University of Yale, New York, and the UK's University of Oxford. And he has made very important contribution towards legal theory, legal philosophy, or jurisprudence. He's known for rejecting both natural law and legal positivism, which we discussed extensively last semester. Now, Ronald Dworkin, in rejecting these two, will actually emphasize what we call the law's interpretive nature. So he comes to the table of legal philosophy saying that instead of having a bifurcation, having a strict dichotomy, natural law thinking, as we have extensively explored last semester, and legal positivism, we should rather look at law as a phenomenon requiring interpretation, that its nature is interpretive. It's done very important works, and some of the leading ones are Taking Right Seriously, which he authored in 1978, and then The Law's Empire, which he entered in 1986. But there are other works, other articles which he did, but I think for our purpose now, it will suffice for us to look at The Law's Empire. We don't need to read Taking Right Seriously. Taking Right Seriously is also a good work. It's available. If you want to read it, I can share a PDF with you, but for our class purpose, we will be reviewing The Law's Empire. So Dworkin critique legal positivism and natural law. And the summary of his attack on natural law can be stated as he having critiqued the a priori reasoning of natural law. If you remember last semester when we learned natural law, a lot of scholars or commentators critique or attack natural law because in their view, natural law proceeds from a priori reasoning. A priori reasoning means that it is steeped in abstraction. You remember, natural law, we say that law must reflect certain higher principles of morality before the positive law will be considered valid. Then you ask yourself, those higher principles of morality, where are they? How do you arrive at them? You know, so they are not concrete, they are not empirical, they are abstraction. And that is what we call a priori reasoning. Now, Dworkin will rather emphasize empirical analysis of legal system, that instead of making unsubstantiated, unverifiable claims about the law, about the legal system, you must rather be interested in finding out the realities that which can be measured, that which can be verified as far as the legal system is concerned. Now, one would say that if Dworkin is attacking natural law and talking the way that I have just stated, then the legal positivists should be very excited because, as you remember, legal positivists like Hart, Bentham, Austin, Kelsen, and all that, all emphasize some aspect of empirical approach to understanding the nature or the phenomenon of law. And for that matter, if Dworkin has critiqued natural law for being an a priori reasoning and rather saying that it should rather embrace empirical analysis, then he is on the same side with the legal positivists. But hang on, wait a minute. Dworkin is not really saying that I am with legal positivists. He also turns around and advances some criticism against legal positivism. Dworkin challenges the legal positivist reduction of law to mere rules. If you remember, one of the most important proponents of legal positivism in our contemporary age is Professor Herbert Lawrence Adolphus Hartz, or simply Professor Hartz, in his famous work, The Concept of Law, which graciously we read together last semester. And as you recall, Hartz in his work, having criticized natural law, having criticized earlier proponents of legal positivism, including Bentham, Austin, Kelsen, and even having criticized some aspect of legal realists, Hart would say that we should look at law from the perspective of rules. If you remember, so law as a rules, they'll talk about the primary rules, the secondary rules, if you remember. Good. Now, Dworkin comes into the picture and says that it is really misleading to look at law as being equal to rules. You cannot just reduce law to just mere rules. Now, Dworkin will rather advocate for importance of moral and ethical standards. That moral and ethical standards are very important in talking about law, and it's not just a matter of rules. Now you see how Dworkin is distancing himself from legal positivists, despite the fact that when he was attacking natural law, he sought to emphasize empirical analysis, and that made us get some hope that he was probably coming to the camp of legal positivists. But then he comes there and said that no, legal positivists, especially when you look at you, Hart, and all those who came after you, you try to reduce law to rules, but law is much more than that. We must rather also look at the moral and ethical standards of law. So, Dworkin look at law as interpretive practice. He said that law is an interpretive practice. And as we go and read the Law's Empire, I mean, basically that is the burden of argument which Dworkin is carrying. Now, when Dworkin says that law is an interpretive practice, his starting premise is that law is more than a system of rules. It includes principles that reflect the community's sense of justice and fairness. So law is not just rules, it also includes principles which reflect the community's sense of justice and fairness. So maybe let's come to our country, Ghana. Can we say that apart from the various laws in the form of rules, as we are familiar with through Article 11 of the 1992 Constitution, adumbrating or listing the various sources of law for us, the Constitution enactment by Parliament, that is House of Parliament, delegated legislation, subsidiary legislation, the existing law, meaning compendium of laws which were in force before 7 January 1993, the common law of Ghana, embracing the doctrines of common law, equity, and customary law as ascertained by superior courts in Ghana. Now, this will constitute what we call, if you like, the rules, right? As far as the law is in Ghana. But Dworkin is saying that the law is not only the rules, but it also includes principles. And the principles is talking about mirror or reflect the community sense of justice and fairness. So when you talk about standards, that's the fairness, Dworkin is saying that beyond the rules, beyond the things we have canvassed, for example, in Article 11 of the Constitution, as I just told you, law encompasses policies and principles that aim at social goals and moral requirements. Well, can we say that the directive principles of state policy, for example, will come under what Dworkin is talking about here? Can we say that maybe the things enshrined in the preamble to the Constitution, some of the values? Now, for judges, when we are sworn, we subscribe what we call the judicial oath. And the judicial oath, among other things, says that you shall administer justice without fear or favor, without ill will or affection, and all that. And you shall do justice to all manner of people. Now, justice, what is it? So these are some of the things which Dworkin is drawing our attention to. So let's look at the point being made by Dworkin that law goes beyond rules, or law is much more than rules, include other things other than rules. Now, on this, Dworkin identifies what we call integrated system. He argues that the law constitutes an integrated system of rules, principles, and policies. So mind you, Dworkin is not saying that rules are not important. No. All that is admonition is that it is too simplistic an approach to simply reduce law to rules and say that once you have your compendium of legal rules, maybe such as the example I gave you from Ghana, let's say you have your source of law as per Article 11 of the Constitution and all that, then you are done with law. No. He is saying that when you have those things, you haven't finished. You must also look for principles and policies. So unlike the legal positivist view, which strictly delineate law as a system of enforceable rules determined by a sovereign authority, Ronald Dworkin's interpretive approach sees law as imbued with moral and ethical consideration that mirror the community's values. So, Dworkin is saying that the community, the legal system, has got certain values. And for that matter, those values must give completion to the law, must give completion to application of the rules at every point in time. And this is very important, especially when we come to interpretation, because you will notice that when the courts are invited to interpret, what it means is that you have an issue of competing meaning. You either have ambiguity in an enactment, or we have lack of clarity, you have vagueness in trying to know the scope of a particular provision of law, or how to properly apply law to certain context or scenario. Now, in talking about law beyond rules, central to Dworkin's theory is the notion that legal practitioners, that the judges in particular, engage in an interpretive process when applying the law. That anytime we are applying the law, we are participating in an exercise in interpretation. And this process, according to Ronald Dworkin, is not about mechanically applying rules, but about understanding and applying the law in a manner that best aligns with the community's moral and ethical values. So it's not just a question of, yes, according to Section 1 of the Road Traffic Act, this and this and that. Okay, so what are the facts? Okay, that is what it says is done. No, it's not just that mechanistic application. But Dworkin is saying that that interpretive enterprise is actually about understanding and applying the law in a manner that best aligns or conform to the community's moral and ethical values. That is very important. So, interestingly, as we speak, Parliament has just passed a bill on proper human sexual values or something like that. So what people simply call the anti-LGBT bill, as it were. And according to Article 106 of the Constitution, when the Parliament has passed the bill, President is supposed to sign it for it to assume the full force of law. The President has not yet assented to the bill, and we have recently been told that some people have gone to the Supreme Court to raise some issues of constitutionality and all that. So we are looking forward to whatever will come out of Supreme Court, and then we incorporate it into our discussion of our present topic. But the takeaway so far is that Dworkin is saying that law is an interpretive process. And this interpretive process is not just mechanically applying rules, but more importantly, understanding and applying the law in a manner that syncs or that conforms to the community's moral and ethical values. Now, in looking at law as interpretive practice or process, principles and policies play integral role. And that is why Dworkin said that law goes beyond rules, and it also includes what principles or policies. So let's say a few more words about that. Principles. Dworkin differentiates or distinguishes between rules and principles. Now, where principles are not applied in all or nothing fashion, but serve as moral guidelines that influence legal reasoning. So when we say that principles are not applied in an all or nothing fashion, we are talking about that principles are not just binary. Binary means that it's either A or B. If it's not A, B, that's it. No any other permutation. So that is saying that you are using all or nothing approach or binary approach. And Dworkin says that no, it is wrong for us to look at principle in that way. That principles are not applied in an all or nothing fashion, but rather principles serve as a moral guidelines that influence how we reason about the law, legal reasoning. So principles demand a level of interpretation and judgment from the courts that goes beyond the binary application of rules. As I say binary, binary simply means that either one or two, either A or B. So that's what we mean by binary. You put things into, if you like, two compartments. If it's not Kofi, then it's Amma. If it's not Amma, then it's Kofi. That's what we mean by saying that you are using binary approach. But he is saying that when the courts are actually interpreting, when the courts are trying to arrive at judgment, the way principles help them in that process is not just a matter of having to make choices between A or B in that simplistic fashion. No. They reflect deeper, the principles reflect deeper societal values, such as fairness, justice, and equality, and require a balancing act in their application to specific cases. So let us keep that in mind. Now, apart from principles, Dworkin also talked about policies. So principles addresses moral and ethical standards, as we have seen. Policies in Dworkin's framework, on the other hand, are about societal goals and objectives. Societal goals and objectives. So maybe in Ghana, we could say that the directive principles of state policy go back to chapter 6 of the Constitution again. Starting from Article 38, I think, to Article 41 or 42, yeah, 41. So those provisions over there, which we call the directive principles of state policy. So go back to them and look at them. Can we say that those directives embody societal goals and objectives? Maybe in your constitutional law, you came across what you call the Lotto case, right? The Lotto case, in which Supreme Court had the opportunity to go to town and extensively discuss the justiciability of the directive principles of state policy and so on. So look at that. So policies direct the law towards certain ends, such as reducing crime, improving public health, or enhancing social welfare. These standards are designed to reach a desired outcome, influencing the interpretation and application of law towards achieving broader social improvements. So you will notice that in recent times, when we are talking about interpretation, I'm sure in your Ghana legal system and legal method, we are giving a little bit of introduction into statutory interpretation. And you have been told what we call the purposive approach, the modern objective purposive approach to interpretation. And that reflects to significant extent what Dworkin is also talking about. And that is why he said that the policies are about societal goals and objectives. So they are standards designed to reach a desired outcome. So when you are interpreting the law, you want to find out what is the purpose? What is this law, this enactment seeking to achieve? So once we ascertain the true purpose of the law, we are put on the right path, the right trajectory to be able to apply the law meaningfully in a way that advances the purpose or the true objective of that law. So that is what Dworkin is reminding us. So standards are important in Dworkin's approach, especially when you see law as interpretive practice. So what are the importance of standards then? Of course, they serve as a moral and ethical dimension. So by incorporating standards that go beyond rigid rules, the law becomes a more flexible instrument capable of adapting to changing societal values and circumstances. Society is dynamic. And if you remember the famous words of Justice Suwa in the celebrated case of Tufo versus Attorney General, when he was trying to caution against a strict doctrinal approach in interpreting the Constitution, he made the point that the Constitution can be likened to an organism. It's a living organism. That society is dynamic. For that matter, the Constitution is also dynamic. It grows, and it must take into account the aspirations of the people and the vision of society, which the people that adopted the Constitution are trying to build. So all those things are important in trying to determine the true understanding of the law or the constitution at every point in time. So these standards, that is the moral and ethical dimension, actually become flexible instruments that enable adaptation to be made to changing societal values and circumstances. Now, let me tell you this. When there are a lot of things which were unheard of, right? So, for example, that if you look at the narrative which is going on with respect to LGBT, you notice that when President Mills was alive, and there was, I think, those was it Tony Blair and so on, there was this thinking that they were going to force Ghana to actually adopt same-sex marriage and all that. You see how there was some kind of like a general societal uproar. However, more than 1.5 decades later, if you carefully analyze the narrative, the discussion which is going on in society, you see people have toned down. People have toned down regarding the issue. Some are becoming more accommodating. Some are adopting a more compromised position that, yes, Ghana should not say that marriage can be between a woman and a woman and man and man. We should maintain the original understanding of marriage. However, if people would indulge in some of these forms of sexual expression, then they shouldn't go to prison for that. If you listen to the discussion going on in the social space, you notice some people are gravitating towards this kind of a compromise or position. But many years ago, there was no such compromise. People were just looking at it in a very strict way. It is this, and no other aspect of the matter should be considered. So this tells you that society is dynamic and social values and circumstances keep changing. And law must have that capacity to actually reflect that flux, that changes going on every now and again. And on this point, I am happy to remember that just about 2 weeks ago, one retired justice of the Court of Appeal called Justice Aduama was saying, he wrote a book, and the title of the book was Dispensing Justice in a Society in a Flux, Walking the Tightrope. And I mean, yours really was a reviewer for that book. So if you look at that book, you notice that the author was trying to canvass some of the essential observations Dworkin has made. And he starts from the premise that justice is not delivered in vacuum. Justice is delivered in society. And society in which justice is delivered is not static. It doesn't stand at one place. The society is undergoing changes. That's what you mean by saying that society is in a state of flux. Now, if that is the case, then it presupposes that those who are involved in the enterprise, in the task of dispensing justice, must also appreciate this changing nature of society and the various contexts which should be taken into account in dispensation of justice. I don't know if there's a copy in your library. Otherwise, if you can get copies for yourself, it's a very good book. When you're also doing civil procedure, you're doing various aspects of the law, jurisprudence, you still benefit from it. Now, in talking about standards, we also have, and we've made the point that you must reflect the community values. So the integration of principles and policies within the law means that legal interpretation is inherently connected to the values and beliefs of the community itself. So this connection ensures that the law remains relevant and responsive to societal needs and aspirations. So a judge or the court cannot be aloof about the society in which the law works, the law is applied. And no wonder the author that I mentioned will say that justice dispensation in any society bears the stamp of that particular society. It reflects the societal needs and then the aspiration in which, I mean, within the society where the justice is actually dispensed or administered. Now, the application of principles and policies requires judges to balance competing interests and consideration. And mind you, society is made up of conflicting or competing interests and consideration. Look at just the example I mentioned. Look at this issue of the LGBT Act, right? We have significant portion of our society who are against it. You have significant portion of our society who will say that let's be careful and all that. So if you have to interpret whether our constitution, for example, frowns upon this or that, the court must actually be conscious of the delicate balance which will need to be negotiated. So the balance is not just about legal technicalities, but involves moral reasoning and ethical judgment, ensuring that legal decisions are grounded in a broader understanding of justice and fairness. So, for example, when it comes to issues of abortion, of course, here in Ghana, we don't actually quibble a lot over whether people can, exercise abortion or not. But if you go to societies like the United States, it's a very big issue. And you might have heard of the case of a Roe against Wade, which sought to largely liberalize the issue of abortion and actually made it much more easier for people who wanted to abort to do so in various states of the United States of America. But if you look at the recent decision of the U.S. Supreme Court about 3, 4, 5 years ago, the court has actually reversed Roe and Wade and making it tougher for abortion, and this has become like a big issue in America. So if you are trying to decide whether a person can opt for an abortion, we have competing interests. The life of the mother, the life of the fetus, the baby in the womb. The baby in the womb, is he a human being or not, and all that. So all these things will have to be factored in. Recently, if you follow the news, I think one state in the US, their state Supreme Court has held that frozen embryos they have the status of the dignity of a human being and all that. And for that matter, You cannot just destroy it. If you did that, you're actually destroying lives. So these are some of the complex issues. Their complexity also lies in the fact that we have contested moral or ethical positions, and the courts will need to navigate a tightrope in trying to ensure that its decisions are grounded in broader understanding of justice and fairness. So what are the implications of the observations Dworkin has made that law is an interpretive practice for legal practice? So we look at judicial discretion first. Dworkin's theory grants significant discretion to judges tasked with interpreting the law in a way that is coherent with both legal precedent and underlying moral principles of the legal system. So judges are given a lot of latitude, a lot of leeway, a lot of room to maneuver if we are going by Dworkin's approach. But as you read Dworkin's Law's Empire and then the right answer thesis, Dworkin is not just giving a blank check to judges or to the courts. No. Dworkin will come from the premise that the judges are actually trained in the legal system. And for that matter, their thinking, their subconscious awareness and all that at every point in time also reflects the deep-seated values which underpin the legal system. So therefore, where they need to engage in any interpretive exercise, as far as the law is concerned, they can be expected to exercise their discretion in a manner which actually reflects these underlying moral principles of the legal system. So this discretion underscores the importance of judicial wisdom and interpretive skills in legal adjudication, that judges have the requisite wisdom because of the fact that they have been trained in the community values, in the underlying values of the legal system. So where we have a very open situation, we should trust that they will fall upon their repertoire, their reservoir of what they know and understand about the legal system to help them to arrive at the right decision. Another point worth knowing is that Dworkin's law as an interpretive practice claim acknowledges the dynamic and evolving nature of legal system. And we've made this point not too long ago. So as societal values shift, so too does the interpretation of law, allowing the legal system to adapt and respond to new challenges and understanding of justice. So law, its interpretation do not stand at one place. It moves with society. It moves with society. So it is dynamic, it's not static. Again, Dworkin interpretivism also blurs the traditional boundaries between law and morality. So as we know from legal positivism and natural law, we have a very strict compartmentalization, a binary approach, law on one side, morality on the other side, as it were. However, Dworkin's interpretism sort of try to tone down the strict separation between law and morality. And that suggests that legal interpretation is an inherently moral endeavor. So if you look at Dworkin's approach, you notice in a sort of way saying that when it comes to the interpretive exercise, inescapably, you are undertaking an exercise in morality. You cannot actually disentangle interpretation of the law from moral evaluation, as it were. That is what Dworkin is trying to say. So you have law and morality being brought together in a very subtle way. There's that kind of unification in a subtle way. And this unity challenges the positivist notion of a clear-cut separation between law and morality, and arguing instead that legal decisions are deeply rooted in moral and ethical considerations. And that is why it's difficult to classify Dworkin as a natural lawyer or as a legal positivist. Now let's look at the role of policy and principle in Dworkin's approach a bit further. In Dworkin's framework, policies are standards aiming at societal goals and improvements. So standards which seek to advance the goals of society or improvements. They articulate objectives that the law seeks to achieve to enhance the welfare of the community. So we have mentioned directive principles of state policy, for example. And if we look at it, there are certain things we as Ghanaians, we want to have, including free, compulsory, universal basic education, and which we started as FK. And if you look at it, gradually, since 1993, a little over 30 years, when we started our 1992 constitution, you see how, as a society, we have made progress towards giving access to education. So go back to 1993 and gradually, how we started from primary schools, gradually JHS, SSS, and so on and so forth. So that is trying to get to the goal or which we have set for ourselves as a society. So these policies, as I said, articulate the objectives that the law seeks to achieve to enhance the welfare of the community. Policies are futuristic. They are future-oriented. They focus on outcomes that lawmakers believe will benefit society, such as public health, safety, economic prosperity, and social justice. So policies are things which are projecting into the future. So are they applied in legal interpretation? Yes. When judges consider policies, they assess the law's impact on societal goals. And this involves an evaluation of how legal decisions will further these objectives, making policy considerations an integral part of legal reasoning in cases where legislative intent and the broader implications of a decision are at play. So as I said, lawyers judges, so to speak, ultimately will have to evaluate policies and how they impact on the law. So examples of policies when it comes to legislative practice, we include environmental laws, for example, aiming at reducing pollution. Public health laws designed to curb drug dependence or some other social evils. And traffic laws focus on road safety are all grounded in policy objectives. And each of these legal areas involves interpreting statutes and regulation in light of the broader societal goal they aim to achieve. So that is how policies actually work in the law as an interpretive exercise or practice. So let's look at the principle aspect, having looked at the policy dimension. So principles, as Dworkin describes, are moral standards that have a dimension of weight or importance in legal interpretation. Unlike policies, principles are not about achieving a specific outcome, but about adhering to moral and ethical standards such as fairness, justice, equality, and respect for individual rights. Principles are timeless and universal, providing a moral compass for the law. So policies, as we have seen, are quite specific. Specific goals we want to achieve as we move towards the future. But principles are not specific goals or specific outcome, but a reflection of the fact that there are certain standards which are always valid, which are always right, and they must actually guide how we apply the law, how we interpret the law. So let's look at the role of policy and principle a bit further. The principles play a crucial role in the interpretive process. They guide judges in making decisions that reflect core moral values. They demand a balancing act where legal practitioners must weigh the principles at stake in particular case, ensuring that the law upholds fundamental ethical standards, even when specific rules seem to point in a different direction. So that is how the interpretive approach to law becomes different from the legal positivism. Because don't forget, legal positivism, the law as rules. So long as you have ascertained the rules, it doesn't matter the outcome and all that. But Dworkin's interpretive approach to the law will require that certain fundamental ethical standards should be upheld when you apply the specific rules, even where the specific rules will be pointing towards a different direction. Maybe we can look at examples of principle, how they play out in the interpretive process. Now, principles are evident in legal doctrines such as the presumption of innocence in criminal law. We look at Article 19 of the Constitution, and we are told that any person who is suspected or alleged to have committed a crime is presumed to be innocent until proven guilty beyond reasonable doubt. The principle of fairness in contract law is another example. especially when it comes to, let's say, the principle of good faith, okay? The principle of good faith. Of course, the principle of good faith in the common law world, as far as contract is concerned, has had a very limited role. And as we notice, good faith becomes important at the negotiation stage of the contract, especially when you are dealing with the contract uberma fidei, contract which requires good faith by its nature, that where a person, by reason of that person's position, is supposed to have certain information regarding what you are contracting about, then he or she cannot remain quiet. Of course, the law, as a general rule, does not impose an obligation for a person to volunteer information or to disclose an information. However, where you find the transaction falling within the category which requires some fiduciary obligation, which required Burma fidei, good faith, then if you withhold material information, that will be a ground for saying that the contract was vitiated, as you remember. So the fairness is not being adhered to. So the principle of fairness is part of, or is a good example of the principle which Dworkin is talking about as being necessary in the interpretive process. And then we also have the principle of non-discrimination in human rights law, especially Article 17 of our Constitution. So if you take that, we are told that we are supposed to avoid discrimination in all forms and in all shapes, gender, sex, race, and so on and so forth. Should never be a reason for being discriminated against. So these are also examples of the fundamental ethical standards which Dworkin is talking about. These principles ensure that legal interpretations and decisions are anchored in fundamental moral values, promoting justice and fairness within the legal system. So let's look at the interaction and balance between policy and principle. How do you balance policies and principle? Ronald Dworkin emphasizes the delicate balance between policies aimed at societal improvements and principles rooted in moral standards. You can have some friction between policies and also principles. You could have a situation where the policy, which is supposed to be achieved, is at variance with underlying principles which promote, fairness and order. So judges often face challenges when policies and principles intersect in complex legal disputes. In such cases, judicial reasoning must navigate this dimension, ensuring that legal decision promotes societal goals without compromising on moral and ethical imperatives. Yeah, so as you can see, it's like walking a tightrope, as I said, as Edward Mose will say in his work. Of course, policy and principle are not necessarily in competition. They're actually complementary in nature. So why policy and principle serve different functions? They are complementary within Dworkin's legal theory. Complementary means that they support each other, they reinforce each other. They are not at war necessarily. They are not in competition necessarily. So policies direct legal evolution toward social or societal betterment, while principles ensure that this progression adheres to ethical standards. Yes, policies would like society to become better and better, materially and all that. That is good. But in our quest to do that, we should also not sacrifice ethical standards. And that is why I give you an example. If we take anti-money laundering, right, laws, that is a good example. You take the Anti-Money Laundering Act, right, and its various regulations. You will notice that people, for example, will get all levels of wealth. So, question is, should society, just a second, let me switch on my air conditioning. Yeah, so should society just be interested in clapping for people that have made huge wealth without caring about how they made it? Of course, in our country, Ghana, if we come outside the circles of the law, the general society, I would like to believe that a lot of people will not care so much about how someone acquired his wealth. All that they care about is that they are getting share of the person's wealth. The person is doing something, is benefiting them. Of course, that is also an unfortunate approach to life. So policies direct legal evolution towards societal betterment, while principles ensure that this progression adheres to ethical standards. And this interplay right between policy and principle is crucial for a legal system that seeks not only to regulate conduct, but also to embody and promote justice. Then it becomes a question of weighting. So how much weight should we give to principles in this interpretive exercise? So let's understand the weight of principles. Now, in Dworkin's view, principles carry moral weight, meaning they represent ethical values that should guide legal reasoning. The weight of a principle indicates its relative importance in a given legal context, reflecting the degree to which it upholds core moral and societal values. So let me give you a typical example. Let's say we have sanctity of life, okay? When you are dealing with whether we should have a law which, for example, says that a woman can choose to have an abortion. Now, life is sacred. So that is a principle. So how much importance should be accorded to the value, the ethical standards of upholding the sacredness or the sanctity of life. So that is what we are talking about. And in determining weights, it is inherently interpretive. In determining the weight to give to principle, it's part of the interpretive exercise, which we are talking about within Dworkinian framework. It requires judges to engage in a form of moral reasoning that considers the broader social implication of applying certain principle over others. In determining weights, it involves an assessment of the principle's underlying values, their relevance to the case at hand, and their compatibility with the overarching aims of justice and fairness within the legal system. And of course, typically, if you take the Supreme Court, for example, in Ghana, we often call it the policy court. And that means that being the apex court or the last court in our country, what it does is not just simply applying the rules, but must also ensure that it negotiates the fine balance between various principles and policies in the way that we have been discussing. And for that matter, sometimes we talk about the doctrine of substantial justice over technicalities, meaning that where the courts have actually done a careful reflection, a careful balancing act, the court could say that, let us go this direction, even if it is not in line with what the technical aspect of the law looks like. Yeah, so how do you balance conflicting principles? How do you navigate conflicts? Legal disputes often present situations where principles are conflicting directly, posing a challenge to legal interpretation. For example, the principle of respecting property rights may conflict with the principle of preventing harm to others. You have to respect property rights, but we also have the principle of preventing harm to others. Let me give you a typical example. When it comes to, let's say, the exercise of eminent domain, compulsory acquisition, or expropriation. Let's say that you have a property at a particular location, right? The property is the property of a citizen, of a particular person. However, if that property is remain at that location, it is going to disable the state from being able to prevent significant harm to so many others. So the state may need to destroy this property belonging to this individual. Now that is a conflict between someone's right to property and also the need to prevent harm to others in society. So that kind of balancing act is what we are talking about. So in such cases, judges are tasked with balancing these principles, determine which should prevail based on their relative moral weight and the specifics of the case. Now, what criteria should guide this balancing exercise? The balancing of principles involves several criteria, including the societal importance of the values its principles represent, the potential impact of their application on the parties involved, and the broader consequences for the legal system and society at large. So this balancing act is not a precise science of maybe mathematics, but a complex exercise in judicial discretion and moral judgment. That is why the task of adjudication requires a lot of maturity and also reflection. So maybe let's look for some examples of the balancing principle. You've mentioned property rights as against preventing harm. So in cases where an individual's property rights may lead to harm to others, such as pollution from a privately owned factory, affecting the surrounding community. So the person has got his factory, is entitled to enjoy the property and use it to make more money and improve his life and that of his family. That is fine. But this factory is also giving so much pollution, poisoning the environment, and making life of people who live within the neighborhood to be at serious risk. So judges must weigh the importance of protecting property rights against the principle of what? Harm prevention. Now, if you look at social contrarian like J.S. Mills, if you remember, Mills talks about what we call the no harm principle. And when J.S. Mills talked about the no harm principle, what he meant was that you have the right, enjoy your right, so long as you do not cause harm to another person. And that you have autonomy. You have the freedom to do whatever, so long as it's not causing harm to another. So that is the no harm principle which J.S. Mills advanced. So in the balancing scenario here too, judges are also actually supposed to pit property rights as against the principle of harm prevention. The decision may hinge on the extent of the harm, the society value placed on environmental protection, and the implications of restricting property rights for the public good. So you see a lot of calibrations, a lot of maneuverings are called for in this balancing exercise. Let's look at another example or scenario of freedom of speech as against the right to privacy. So this is a very common conflict area. And the conflict arises between the principle of freedom of speech and the right to privacy. And this is how it manifests. When does the public interest served by free expression outweighs an individual's right to privacy. And this is very important. I think there's especially when it comes to people's private life, public officers, celebrities, and all that. How do you draw the line? Which aspect of their life can be subject matter of media discussion, publications, and all that? And which aspects are actually totally private? Legal judgments in such cases reflect a weighing of principles, considering factors like the nature of the information being disclosed, its relevance to public discourse, and the potential harm to the individual's privacy. When it comes to defamation, especially, the involving people, especially people in the public affairs and so on, or in modern age, something called celebrities. The courts actually are confronted with how to balance free speech against the right to privacy, as it were. Now, what are the implications for this aspect of Dworkin's interpretive approach to legal practice? Now, the task of balancing principles involves the significant responsibility placed on judges to interpret the law in a way that faithfully represents societal values and ethical standards. This requires not only legal expertise, but also moral insight and ability to navigate the complex terrain of human values and societal needs. So judges and lawyers, for that matter, are supposed to be well-rounded, well-informed, well-read. Again, the concept of principles and their weights, as we have seen, highlight the dynamic nature of legal interpretation. As societal values evolve, so too do the relative weight of principles. And this makes it necessary for us to have ongoing reflection and adaptation by the legal system to remain aligned with contemporary moral and ethical standards. And again, I refer you to the dictum of Justice Sowa in 2-4 versus Attorney General, that the Constitution mirrors the history and aspirations of the people. It does not admit of doctrinal interpretation. It must accommodate the various changes which society is witnessing. I'll give you a typical example. Let's say that at the time that we adopted the Constitution, there are certain things which were probably not known, okay? So let's take the Bank of Ghana. If you go to the Constitution, among other things, you have the monetary policy regulation and all that. The Bank of Ghana is supposed to see to it. And there's something we call cryptocurrency now, which is a certain form of money. And that has also got its own economy. At the time of, let's say, adopting our 1992 Constitution, that was unknown. So, would you say that because it was unknown, the power of Bank of Ghana to regulate banking industry, to play a key, a leading role in policing the monetary environment and all that, should not include cryptocurrency? Certainly not, because law and its interpretation, its application must actually conform to some of these changes in society, because of the law being in a state of flux all the time. So let's keep that in mind. Now, Dworkin also criticized the approach which natural law and legal positivism had as far as law and morality is concerned. And he rather advocates a unified approach. But the unified approach is not the same as how the natural law scholars look at law and morality. But let's look at the critique he gave to legal positivism. As we have noted earlier in this lecture, Dworkin challenges the core tenet of legal positivism that law can be understood independently of moral consideration. I mean, that is what the legal positivist says. Now, Dworkin argues that such a separation is artificial and untenable, as legal decision-making inevitably involves moral judgments. And we've seen that substantially this morning. This critique, which Dworkin is making, is pivotal, suggesting that law without moral grounding risks arbitrariness and may fail to achieve justice. Now, later on, as you read his work, The Law's Empire, he has what we call the imaginary character, Hercules, which he uses to advance his ideas. And you see the various things that he sought to do. But you read it, so I'm going to put that on hold for now. Now, Dworkin's theory proposes that legal decisions should not only apply legal rules, but also makes it explicit that moral judgments that underlie these decisions. So don't only apply legal rules, but you must also make explicit the moral judgments that underlie the decisions we have arrived at using the legal rules. And this requires judges to interpret legal texts and precedents in a way that is coherent with underlying moral principles. And this will ensure that law serves the ends of justice in a more comprehensive sense. So legal texts and precedents should be approached in that order. And that is why when it comes to the doctrine of judicial precedent, okay, you notice we have what we call distinguishing, where there is a precedent which may be binding. However, if you are to follow it, because the material facts before you is in a particular way fundamentally different from the material facts within which the particular precedent you have to apply was decided, we try to demonstrate that important difference, that differentiation, that distinction, and say that because there is this particular aspect of material fact in this scenario that was lacking in the precedent we have to follow. Therefore, I am not going to follow this precedent because it is not on all fours with the scenario before me. Now, that has enabled you to avoid artificiality. Just slavish following or adherence of precedent, which will have resulted in injustice. So that is the kind of thing Dworkin is reminding us. So Dworkin advances what we call the community's morality and legal decisions. Dworkin emphasizes that the law is a reflection of the moral standards of the community itself. And this view asserts that legal norms and decisions should be aligned with the community's ethical values, ensuring that the law remains relevant and responsive to societal needs and expectations. In that regard, the relationship between law and morality, according to Ronald Dworkin, is dynamic and reciprocal. Dynamic means that the relationship is an evolving relationship. Reciprocal in the sense that there's mutuality. They reinforce each other. Legal system influence societal moral standards. Societal moral standards are also influenced by legal system. So that is the reciprocity we are talking about, that mutuality. So as societal values evolve, so too must the legal interpretations and judgments, ensuring that the law progresses in tandem with changing moral understandings. And mind you, if you look at our Constitution, I think Article 129, Article 129, if I don't have my Constitution readily with me, if you look at our Constitution, for example, the Supreme Court, right, is not supposed to follow decisions of any other courts and all that. And then we are told that the Supreme Court may depart from its constitution, its precedents, where it's considered it's proper or fit so to do. I'm just trying to get the provision for you and read it. Or if someone has it. 1992 Constitution. Yeah, but that is the point that the Supreme Court may actually depart from its decision where it considers it necessary to do that. And that is where I want to link it with what Dworkin is telling us. That the law is not static, society is not static and all that. And for that matter, where maybe a particular precedent, the Supreme Court propounded a particular precedent. In the course of time, the Supreme Court may look at it and say that, yes, we have a good reason to make a departure from this precedent so that it's no longer a good law. The court may do that. You remember the case of Mensa and Mensa with respect to spousal property rights under the Constitution. If you look at the Constitution, Parliament is supposed to enact law which would enable spouses to actually manage their property rights and all that. Should there be divorce and all that? Now, that has not been done. And if you remember Mensa and Mensa line of jurisprudence, the Supreme Court was worried that the inaction by Parliament was actually resulting in injustice to certain spouses when there's a divorce, especially women. So they adopted what you called the 50-50 or the equality is equity approach when it comes to this distribution, and also said that when you talk about contribution is not only financial contribution, but also some other forms of support which the spouses provide towards each other and all that. Now that was a epochal or a landmark decision. But after over 10 years or know that the courts have had to revisit that precedent and said that it's not automatic that when there's a divorce that the parties should share the property. We still entertain possibility of a spouse being able to adduce compelling evidence to show that, despite the fact that the properties were acquired during the marriage, he or she made substantial contribution which warrant that it should not be shared equally between them. So that is an example of how the application of precedents evolves to reflect the changing needs of society. And this enables it to serve the ends of justice in a more comprehensive sense. Again, we have also said that the interplay between law and morality is forward and backward. That is reciprocal. So they support each other. The implications for all this is that Dworkin's unified approach, when we say his unified approach, that is approach that law and morality should not be separated in the way that legal positivists would argue. His unified approach assigns a significant moral responsibility to judges, lawmakers, and legal practitioners. They are tasked with not only interpreting and applying the law, but also with ensuring that legal decisions reflect and reinforce the ethical values of the society. So that is one point to note. Again, by grounding legal decision in the moral values of the community, Dworkin's approach seeks to enhance the perceived justice and legitimacy of the legal system. And this alignment between law and morality serves to strengthen societal trust in the legal system and its capacity to deliver fair and just outcome. And this is very important because if society should lose trust, should lose confidence in the capacity of the justice delivery system, in the capacity of the legal system to advance fairness and justice, you can imagine the chaos which we have on our hand. People will be attacking one another. Nobody will care about law. Nobody will care about the legal and the judicial institutions, as it were. Again, Dworkin's theories contribute to broader debates on legal moralism, the idea that the law should enforce societal morals. So while he advocates for a moral basis in legal interpretation, Dworkin also acknowledges the complexity of balancing moral judgments with individual rights and freedoms. And in that regard, he highlights the nuanced role of morality in legal decision-making. So he's not saying that morality is not important. Morality is important. But he's also not saying that it's all about morality. No. It is a very conscious effort to try and dwell upon all this in a harmonious fashion. Dworkin actually rejects positivism judge-made law, and he presents a compelling counter-argument that reshapes our understanding of the judicial role and legal interpretation. Now, Dworkin's contention with positivism lies in its implication that law is a set of rules directly created or modified by judicial decisions. So that is what the positivists will have us believe. Now, Dworkin, on the other hand, argues for a more detailed, a more rounded, nuanced understanding of the judicial role, and emphasizes that the discovery of the right answer through application of legal principles is what is important rather than the creation of the new law. So it's not so much about you creating a new law as the legal positivists will have us believe in a sense, but in every situation, in every case, or what he calls like the hard case. Hard cases, that is where you do not have any direct precedent which governs that case. Then Dworkin will say that it's still possible for the judge, for the court to come out with the right answer because of his appreciation of the underlying community ethos, community values. So Dworkin has a problem with legal positivism because he says that they have a misconception of what judicial rule. And Dworkin argues that legal positivism mischaracterizes the nature of judicial decision-making by suggesting that judges have the authority to create law in the process of adjudication. Now, Dworkin disagrees with that. And according to him, this view of legal positivists overlooks the interpretive aspect of legal practice, where judges are engaged in uncovering the law's content, not in creating it ex nihilo. That is, creating it from nothing. Let me put it this way. Legal positivists, they talk about the fact that yes, the parliament makes law, judges also through judicial president makes law, and so on. That is what positivist says. Now, Dworkin is saying that that is not really the case. judges don't make law. Even where you have the so-called hard cases, that is those type of cases in which you think that there is no manifest direct precedent which will guide the court, judges are still not making law. Judges are going to dwell upon their repertoire of knowledge and experience from the legal system in terms of the underlying values, the underlying principles of the legal system, to try and discover that which is already there. So we try to uncover the law's content, and they are not really creating a new law. So that is what Dworkin is saying. And again, Dworkin makes the point that the approach of legal positivism on judgment law or judicial or precedents risks undermining the coherence and integrity of the legal system. Dworkin is of the view that there is coherence, there is integrity in the legal system, but if you go according to how positivists are looking at precedents, then what it means is that you are throwing away coherence and integrity which exists in the system. And Dworkin will make the point that the positivist approach with respect to precedent, as we have explained, suggests a fragmentation of law, that is breaking down law into isolated decisions rather than viewing it as a unified body of principles that guide judicial reasoning. Dworkin is saying that law cannot be fragmented. Law cannot be broken into smaller units or compartments, and then each being on its own without any coherence. No, that to Dworkin is wrong. And that is why he is attacking positivism. Now, what alternative does Dworkin provide to what he has perceived as a mistaken approach by legal positivists as far as judicial precedent is concerned? Now, Dworkin's alternative is what we call law as principled decision-making, the right answer thesis. Now, central to Dworkin's theory is a belief that for every legal question, there exists a right answer that judges must strive to discover. So there is nothing like a hard case in the sense of a case not having any direct legal solution, as it were. And that this answer is not subjective, but is grounded in the network of legal principles, rights, and duties that compose the legal system. And this is the crux of the matter, what we've been saying so far. And that is why he's saying that the judge is part of the legal community. The judge grew up in the legal community. The judge went to school in the legal community. So he or she becomes exposed to the legal principles, rights and duties, values, which compose the legal system. So if there is any situation, in the absence of direct precedent, we should trust that the judge will be able to leverage upon all this special background he has by reason of being a member of the community and having been schooled in the community legal system and all that, to be able to come out with the right answer. This perspective does not deny the complexity of legal disputes or the challenges in interpreting the law, but asserts that principled reasoning can lead to objectively justifiable outcomes. So that is what Dworkin is telling us. So let's look at the role of principles in judicial decision-making then. Unlike positivist view that emphasizes rules as the core of law, Dworkin places significant weight on legal principles. These principles are not created anew with each decision, but are discovered through the interpretation of existing legal materials, including statutes, principles, and constitutional texts. Judges, in Dworkin's view, act more as interpreters of a vast and a coherent legal landscape, rather than as legislators of new laws. So unlike what positivists will have us believe that judges make laws, Dworkin does not say it that way. Dworkin says that judges are interpreters of a vast landscape which is coherent in the sense that there's a fix, there's a harmony, there's integrity. So what does Dworkin mean by looking at law as integrity? Dworkin introduces the concept of law as integrity, which posits that legal actors should treat the law as expressing a coherent set of principles about justice, fairness, and procedural due process. Judges, therefore, must interpret laws in a way that upholds this coherence, reinforcing the law's integrity across cases and over time. So that is what Dworkin means by the law as well, as integrity. So meaning that there's that kind of cooperation, there's that kind of coordination, and every aspect of the law reinforces the other. So if you as a judge, you are interpreting or applying the law, that appreciation should be clear to you, that there's no disharmony in the law. What are the implications of the alternative proposed by Dworkin, I mean, to what the legal positivist said as far as judicial precedent is concerned? Now, under Dworkin's framework, the judicial role is characterized by a deep responsibility to legal tradition and community moral standards. Judges must exercise creativity, not in creating new laws, but in interpreting and applying existing principles to complex and evolving societal contexts. So on this, I'm going to give you, I'll send you some cases which I would like you to read. And then I would like you to bring your reflection of what Dworkin is saying to bear on the case that you have read. And then tell me whether what you have read in the case reinforces or undermines the argument Dworkin is making. Again, Dworkin's rejection of judge-made law challenges legal education and practice to adopt a more principle-oriented approach It calls for a re-evaluation of how future lawyers, and of course you, are trained. And it also emphasizes the importance of moral and ethical reasoning in legal analysis. And that is why those of you in a Presbyterian university, you are blessed that you are also taught some ethics and all those areas of knowledge which you are being exposed to, you will have to leverage on them at some point in time. And that is the kind of thing Dworkin is telling us. Furthermore, by grounding judicial decision-making in the principles embedded within the legal system, Dworkin's view enhances democratic legitimacy of the judiciary. And that is very important, especially when there's a concern about separation of powers. The fact that the executive, they are elected, the legislature, they are elected. You judges are not elected, and yet you would like to have the final say when there's controversy in society. You take Supreme Court, that they are not elected. You take all the judges at the various levels of the judiciary, they are not elected. For our MPs, they are elected. Our assemblymen, they are elected. Our president, ministers, and all that, they are elected. So we can hold them accountable in that regard. But judges are not elected. So why should they impose their views on us and reject that which the elected representative have actually legislated for us? And this is where Dworkin becomes a very useful asset, because if you are using Dworkin's approach, you are going to say that judges do not make laws. Judges only seek to uncover, seek to discover that which is already in the legal system. And that which is already in the legal system was actually made by the elected representatives and so on. So Dworkin's alternative enhances democratic legitimacy of the judiciary. And then it actually shuts any accusation that may be leveled against the judiciary that it is not elected. And for that matter, it must not actually so pretend over choices made by elected representative of the people, as it were. Dworkin's approach aligns judicial decisions with the values and principles that the community, through its legal traditions, has endorsed, as we have explained. Now, just before we go, I want us to finish Dworkin so that we don't come back to this class again. Let's say a few words about rights and their protection within Dworkin's theory. So he distinguishes between abstract and concrete rights, and also emphasizes their inviolability. Now, this perspective of Dworkin, of trying to draw a distinction between abstract and concrete rights and inviolability, not only delineates a sophisticated categorization of rights, but also underscores the profound ethical commitment of the legal system to protect these rights as manifestations of individual dignity and societal values. So let's take what it means by abstract right as opposed to concrete rights. Abstract rights are broad, fundamental principles that reflect the moral and ethical underpinnings of a society. Abstract rights are not tied to specific legal codes, but are understood as inherent to the human condition. They represent essential freedoms and entitlements. So those are, and a good example would be maybe the right to liberty, the right to equality, and the right to freedom of expression. Now, you remember last semester when we were talking about John Finnis, his restatement of natural law, when you talk about the flourishing of human being, conditions for flourishing of human being is irreducible, 7 basic goods and all that. So in a similar vein, Dworkin is also saying that abstract rights are inherent to the human condition. And he's giving us example: right to liberty, right to equality, right to freedom of expression. These rights are interpretive in nature, requiring a contextual understanding and application to specific circumstances. Right to liberty is just, if you like, empty, unless you contextualize it, you apply it to a very specific situation. And that is why we are saying that they are all interpretive in nature. Right to equality. Look at article, look at the Constitution. Equality. What does it mean? Does equality mean making everybody the same? No. What about affirmative action? So these are what he means by saying that they are interpretive in nature. So they serve as moral guides for the development and interpretation of concrete legal rights. So what then are the concrete rights, having known the abstract rights? Concrete rights are specific, codified entitlements that arise from abstract rights tailored to particular legal contexts and situations. So they are explicitly defined within the legal system, and they provide clear entitlements or protections under the law. The examples include the right to a fair trial, for example, as we have in Article 19 of the Constitution, the right to privacy in specific circumstances, or the right to vote. So as we will see, concrete rights operationalize the abstract principles and make the abstract principles enforceable and actionable within the legal framework. No, he also talked about inviolability of rights. So what does he mean by saying that rights are inviolable? That is to say that there's a moral obligation to protect these rights against infringement, against infractions, against violations or breaches. So the inviolability reflects the intrinsic value, the inherent value and dignity of individuals, asserting that certain rights must be preserved even in the face of competing societal interests or utilitarian consideration. So we'll give you, sometimes let me give you this typical example. The right to fair trial, okay? Presumption of innocence is part of the right to fair trial. You have seen someone actually killing another person. You saw it happen. So you have the offense of murder. Now, the right to fair trial, which includes presumption of innocence, says that regardless, you must still take this person through due process. You have to go through every procedure. You don't just say that, yes, but you saw the person in the act. So why do you have to try the person? Why do you have to waste resources and precious time? No. Now, Dworkin also made a famous argument that rights function as trumps. I'm not talking about Donald Trump, the name, no. Right functions as trumps over collective goals or the general welfare. Of course, this trumps, right as trumps is talking about is actually a metaphor. And this metaphor highlights the priority given to individual rights in the legal and moral hierarchy, asserting that the protection of individual rights should prevail over the pursuit of societal or governmental objectives that might compromise these rights. So right or trump, you know what you call like a trump card? Yes. So to supersede, as it were, that's what it means. And that is why when it comes to, let's say, look at Article 20, for example, compulsory acquisition, okay? We need to build a road. We need to pull down your house so that the road can be expanded. The road is a collective or general welfare thing for everybody in the society. The house is for you. But your right to property will trump. And that is why Article 20 and also the Land Act will give elaborate provision on how there should be valuation, how you should be adequately and promptly be compensated and all that. So, Dworkin's right as trump is crucial in legal adjudication, especially where the balance between individual rights and public interest is often at stake. So let's keep that in mind. What does this imply for legal practice and theory of law in general? We talk about this back and forth, so, but suffice to note that the distinction Dworkin makes between abstract and concrete rights, as well as his principle of their inviolability, introduces a significant moral dimension to legal interpretation and judicial decision-making. Judges and legal practitioners are called to navigate not only the letter of the law, but also its ethical implication. So if you look at the Constitution of Ghana, look at Article 12, right, which begins chapter 5, Fundamental Human Rights and Freedoms. We are told that the judiciary, as well as other arms of government and institutions, are supposed to actually uphold the fundamental human rights and freedoms enshrined in the Constitution. Again, we have seen how Dworkin's approach actually undermines positivist legal norms. If you look at positivism, as you remember from last semester, they emphasize the source of the law. sovereignty of lawmaking bodies. And then once something has come from the lawmaking bodies, that is it. That is the law. But Dworkin disagrees, and he advocates for a jurisprudence that integrates ethical reasoning with legal analysis. And that reinforces the law's role in upholding justice and human dignity. Of course, Dworkin also, by distinguishing between abstract and concrete rights and asserting their inviolability, provide a framework for rights adjudication. There's a topic we call right analysis, which we will discuss later. And you notice that knowing this abstract as opposed to concrete rights can provide a very useful guide. And when it comes to interpretation of laws and resolution of legal disputes in a manner that respects and protects the core values and principles of a just society. Let's look at these Trump rights in relation to government policy. We have noted that Trump rights are those individual rights and freedoms that have precedence over collective goals or government policies. If you look at the metaphor, the figurative use terms, it will suggest that in a conflict between an individual rights and government policy objective, the individual rights should prevail. Of course, you want to go back to the social contract theory, which we learned last semester. It will not be difficult for you to appreciate this particular metaphor. In a broader sense, this prioritization, which is being given to the individual right, is grounded in the belief that protecting individual autonomy and dignity is a fundamental obligation of justice. And this is a reflection of a commitment to the inherent value of each person. And as I said, you can also reinforce this from some of the claims of social contract theories, as we saw last semester. So how does this apply when it comes to legal decision making? Courts are tasked with evaluating whether an individual's rights should trump the government policy objectives. And for example, there's this scenario I want to avoid, but I keep coming back to it. So let's suppose that you get a group of individuals, okay, who go to court and say that for them, they are LGBT people and they want society to recognize them so that they are not excluded from enjoying various opportunities and services which society provide. And that they are aware that they are not supposed to be discriminated against in terms of Article 17 of the Constitution. And although certain grounds of discrimination are stated in Article 17, they are not exhaustive. And they're also mindful of Article 33, which says that the rights and freedoms enshrined in the Constitution are not exhaustive, but rights and freedoms which are inherent for enjoyment of democracy, not expressly stated, are also part of their compendium of rights. So they want the courts to give effect to that. So here, we're getting, if you like, individual rights coming into conflict with the collective one. Of course, this matter is sub judice, so we cannot say further about it. Now, are there any justification for overriding rights? Now, Dworkin in a way, emphasizes the paramount importance of Trump rights, as we have seen. He also acknowledges scenarios in which the overriding of such rights might be justifiable. So the situation where you may have to ignore, if you like, the individual right, who should have trumped that of the collective or government policy. But these exceptions are not taken lightly. They require rigorous scrutiny to ensure that the infringement upon individual right is both necessary and proportionate. So the Dworkin doctrine of necessity and proportionality. So if you are going to infringe or you are going to, ignore individual right so as to advance government policy, so as to advance the collective, is it absurd? What you are doing, is it absolutely necessary? Being absolutely necessary means that you cannot achieve what you are going to achieve unless you infringe upon individual rights. Then proportionality. The measure or the scale of activity you are doing, which is going to infringe the individual right. Is it just what is needed, or what you are doing is more than what is required? Then we also have another justification for overriding a right. The individual, when the values protected by the right are not at stake in a particular marginal case. So here, the government must demonstrate that the specific circumstances do not fall under the core protection intended by the right. And that will make the infringement permissible. So this is where the courts, the Supreme Court, the Human Rights Court, will have a lot of creative thinking and analysis to do. Another scenario involves where defining a right too broadly will impinge upon other significant rights or other interests. So the government must show that the broader definition of the right will lead to unacceptable encroachments on other equally important rights or other critical societal values, which will necessitate a limitation on the original right. So let's take this legislation, Persons with Disability Act, okay? Right of person with disability. If you look at it in a context of a society where we have serious resources challenge. Now, if you are to take that legislation to its logical conclusion, one will argue that almost all public buildings will need to be redesigned to have disability friendly access. Otherwise, you are infringing on the right of person with disability. Then we come to a justification which may be disproportionate cost to society. So if society will have to spend so much in order to advance or to help the particular right to be enjoyed, then the prohibitive cost will be a good justification for actually undermining or sidestepping that particular right. So let's keep that in mind. But of course, there are ethical and legal implications for all this. So the concept of Trump rights and the conditions which they may be overriding reflects Dworkin's commitment to legal system that upholds the moral integrity of society. So don't forget this law as integrity, which we discussed not too long ago. So by establishing a high threshold for overriding individuals' rights, Dworkin's legal framework ensures that the law remains a protector of individual dignity and autonomy. Again, Dworkin's approach provides a nuanced framework for balancing individual freedoms against legitimate government policy. Maybe I will take your minds back to COVID-19, okay? And then the Imposition of Restoration Act, and also other public health regulations. Furthermore, the discussion of Trump rights and the justification for their potential override, as we have discussed, serves as essential guidance for judges and policymakers, as it emphasizes the importance of rigorous scrutiny in cases involving potential infringements on individual rights, ensuring that any limitations are justified, necessary, and proportionate to the legitimate aims being pursued. We come to the last aspect of our discussion of Dworkin, extending the law's empire. Extending the law's empire. Now, Dworkin articulates a vision of law that is not merely reactive or grounded in precedent, but rather proactive and forward-looking, and at the same time, deeply rooted in fundamental principles of justice and morality, as we have seen. And that vision reflects a constructive attitude toward law and its role in society. And it also emphasizes law's capacity to shape and guide societal evolution towards a better future. So Dworkin's concept of the law's empire, what we call the empire of the law, he has a work, as I've told you, are going to read, The Law's Empire. It expands the domain of legal influence and stresses the importance of a legal system that is coherent, morally principled, and dedicated to protection and interpretation of rights within a framework of ethical standards. So Dworkin's Law's Empire has a constructive attitude toward law. He advocates for a jurisprudence that looks forward as much as it looks backward. So in that regard, while historical precedents and established principles provide a foundation, the law must also adapt to evolving societal values and moral understanding. And such an approach requires a constructive attitude, where legal actors, especially judges, view themselves as participants in the ongoing project of building a just society. So the work of a judge, the work of adjudication, and all that should be seen as a project which is not finished, an ongoing project of building a just society. So anytime you have to apply precedent, you need to interpret the law, these things should come to the fore of your mind. Achieving a better future through the law involves a delicate balance between respecting the history of the law and being responsive to contemporary moral and ethical challenges. Again, I refer you to former Attorney General Dictum of SOA. So Dworkin suggests that this balance is achievable through principled interpretation, where past decisions are honored, but not allowed to unduly constrain the pursuit of current and future justice. Precedents are very good, but we should be very open and flexible, knowing that there is an ongoing dialogue between the past and the future. What about legal practitioners? Under this constructive vision, legal practitioners are seen as the architects of the law's future, tasked with ensuring that legal developments are not only consistent with established principles, but also reflective of an evolving moral consensus. Now, that is why as students of the law, you are supposed to be very knowledgeable, because the courts are there. The courts can only do so much, especially in our adversarial litigation system. The judge cannot bring cases on his or her own. The judge cannot bring completely new arguments unrelated to the case before it. The lawyers for the parties before the court, they must actually do that. And that is why in this constructive attitude toward the law, lawyers, and for that matter, legal practitioners have got a role to play. Yeah, so what are the principles and the rights that have to be at the fore? So at the heart of the law's empire, or empire of the law, is the recognition and maintenance of individual and collective rights. Dworkin posits that a just legal system must be unwavering in its commitment to protecting rights, especially those that project individual autonomy and dignity. And this commitment requires a continuous process of identifying, trying to find out, articulating, and enforcing rights in line with moral and ethical standards, which we have been discussing a lot today. Now, extending the law's empire involves interpreting legal rights, not in isolation, but in the context of broader moral principles that underpin the legal system. And this interpretive process, according to Dworkin, ensures that rights are understood as part of cohesive moral framework, lending legitimacy and coherence to law as a whole. So if you go and read his book, The Law's Empire, you talk about the fifth principle, FIT. Now, Dworkin's vision also embraces a dynamic interaction between law and morality, where legal interpretation and decisions are informed by, and in turn, inform societal understanding of justice and ethics. So let's keep that in mind, and especially so as you go and read the book I am directing you to, The Law's Empire. Now, we want to sign off by looking at contribution which Dworkin has made as far as legal theory or jurisprudence is concerned. First, he has challenged traditional legal views, and you have appreciated this so far. Dworkin's work proposes an integrated approach to legal theory, where law is seen not merely as a set of rules to be mechanically applied, but a coherent system. So we've discussed that a lot. Again, central to Dworkin legacy is the emphasis on principles and rights as foundational elements of law. Now, as you remember, Hart talks about rules, right? And Hart will say that a union of primary and secondary rules will give you a legal system. But Dworkin is saying that principles and rights are the foundational elements of law. Now, his argument that rights should be treated as trumps over collective or governmental interests highlights the primacy of individual freedoms and dignity within a legal system. Again, in terms of legacy, Dworkin's work is very relevant and has influenced contemporary legal thought in many ways. So Dworkin's assertion of the importance of moral judgment in legal decision-making continues to influence contemporary legal thought, advocating for jurisprudence that recognizes the ethical dimensions of law. And this is quite critical in an era where legal systems are increasingly called upon to address complex ethical dilemmas and societal issues. But we should remember that despite observation we made last semester, that every jurist, every proponent of a school of jurisprudence is a product of his own society, and for that matter, what he or she is trying to propound will be useful largely to the particular legal system it's accustomed to. It bears emphasis to note that the relevance of Dworkin theories transcends national legal systems, offering insights that are applicable globally, including our own jurisdiction. Its emphasis on moral reasoning and integration of ethical consideration into legal interpretation provides a valuable framework for addressing unique challenges faced by diverse legal systems. So his ideas are not only limited to America or to UK, as it were. Now, how is Dworkin's thinking relevant to our legal system and statutory interpretation? Ghana legal system, as we know, like many others, is based on a combination of statutory laws, common laws, customary laws. And Dworkin's theories underscore the importance of integrating moral and ethical considerations into the interpretation of these laws, ensuring that legal decisions reflect not only the letter of the law, but also societal values and principles of justice, which we'll be discussing. Again, it provides guidance for judicial decision-making. And all the things that we said are applicable to Ghana in a sense. So judges can draw on Dworkin's approach to interpret statutes in a way that aligns with broader ethical standards and principles of fairness, justice, and respect for individual rights. And again, Dworkin's theories are particularly useful to us in Ghana, especially where our legal system is evolving to address new societal, economic, and technological challenges. I am a student of medical law, healthcare law. So when it comes to areas of medical advances, reproductive medicine and all that, IVF, when it comes to organ transplantation, these are areas where the law is lagging behind technology, and there will be cases, there will be need for the law to be interpreted to address new challenges. which are these areas of, let's say, medical practice. And so by advocating for a legal approach that is responsive to contemporary moral and ethical values, Dworkin's work encourages our system to adapt and evolve in a manner that serves the needs and aspirations of society. Yeah, so let us take note of this. What is left is actually critique of Dworkin, but at this stage, will not let us discuss the critique as we go and read the work, The Law's Empire, and then the questions that I will direct you to. We come back to any criticism which may be leveled against Dworkin. So I will take questions and then we'll end the class and get ready for company law. You have to raise up your hand if you want to speak. We have muted all of you. Prefect, do you have any class apart from my classes today?